Thank you, Honorable Chief Justice. My name is Elias Mutuma. I appear for the 7th, 8th, and 9th respondents. I appear alongside Counsel Caroline Gerono. For the record, my lady, we have filed our submissions dated 9th of December 2021 and a case digest dated 21st of December 2021. I will be tackling 3 issues. One is the nature of a popular initiative and whether it is available for use by the President or the state. I'll also tackle the issue of public participation in as far as a popular initiative is concerned. My lady and my lords, I am persuaded to rely on the words of Shakespeare, who says that a rose by any other name shall still smell as sweet. I wish to add that a skunk, in the same measure, by any other name shall smell as bad. My Lord, this initiative that has been brought to your attention has been branded a popular initiative. There is no name changing that is going to change the character of this initiative. It remains a skunk. It remains a presidential initiative as opposed to a popular initiative. And I'll demonstrate that as we proceed. It is our submission, my lady and my lords, that the President is expressly prohibited from pursuing a popular initiative as a means to amend the Constitution. I will be supporting that argument with 2 grounds. One is the fact that sovereign power belongs to the people. This is captured under Article 1 of our Constitution, where the people can exercise that power directly or indirectly. A constitutional change process is a legislative duty, part of the sovereign power that the people can exercise. They either exercise that legislative duty directly or indirectly. In some instances, the people have donated that legislative duty to Parliament, and only Parliament, not to any other person. At no point have the people donated or delegated legislative power to the President. Constitution. Article 1 of the Constitution, again, is very clear that power is exercised directly or indirectly. And my point is, the words used are either or, so that when the people exercise direct authority to legislate, then there is no other body that can exercise that power on their behalf. The words used are either or, not both. The provisions of Article 131, and I want to address my landed senior, Mr. Kamau Karori, do not include legislative duty. The President cannot seek refuge under Article 131. In fact, from 129, 130, 131, and 132, to purport to exercise executive authority in a manner to change the Constitution. Executive authority is the power to govern. It is not the power to legislate. So what Article 129 to 132 provides is for the President to govern. Legislating is not provided for under those articles. So he cannot act as a symbol of national unity and then purport to legislate, it would be usurping the role of the legislature. And by this I mean legislature, either Wanjiku herself or Parliament. There isn't any other person that can legislate. Indeed, if the president was to be allowed then to initiate a popular initiative or in any other way legislate, that would amount to acting ultra vires by going against the doctrine of separation of powers. Again, I emphasize that legislative must be distinguished from exercise of executive authority. And in case we have any doubt, my lady and my lords, as to what it means to legislate, a first-year law student knows that legislation is the process of enacting into law. And enacting is a process that begins at the point of framing or drafting the proposed law and will culminate with approval of that law. There are quite some processes in between. Therefore then, the person who enacts a law must be the person who frames a proposed law. So if the president frames, conceives the idea that we need to amend the law, then it is him who is enacting that law. When you look at Article 255 of our Constitution, and allow me to read, my lords and ladies, is that it provides as follows: a proposed amendment to this Constitution shall be enacted in accordance with Article 256 and 257. The word used is enacted, and approved in accordance with Clause 2 by a referendum. We therefore must interrogate, what does it mean to enact? So that when the Article 257 provides for the people to enact an amendment to the Constitution, it means, number one, they must be involved in the process of preparation and formulation of the proposed law. That is the first step. If they are not involved in the process of creation, formulation of that proposed law, then they are not involved in the process of enactment. The second phase of enactment is creation of awareness and consultation. In the case of Parliament, a bill is sponsored by a member of Parliament. It is introduced to the House through the first reading, and this is where members of Parliament get to interact with the proposed law. Now, in the event of a popular initiative, the question that we should ask ourselves is, did the people formulate the proposed amendment? Because you've been told by my learned friend, my good friend Jackson Awele and Arnold Oginga, that what preceded the collection of signatures did not matter. That it doesn't matter that the people did not formulate, did not prepare that bill. What matters is that we had 1 million signatures. That whoever initiated the process does not matter. It is inconsequential. I beg to differ. The third stage of enactment is content deliberation. In legislative terms, when it comes to Parliament, that is called the committee stage, where now the issues are brought before the members of the Parliament. They deliberate over the content with a view of persuading each other on whether we need to retain certain content or remove them. Now, at what point did the people, in exercise of their direct legislative duty under Article 257, undertake this process? You will not find that anywhere. Instead, what you're being told is that it is enough that the people will have an opportunity to vote at a referendum. And we have seen Article 255 talks about enactment and approve by way of a referendum. So how then are they exercising their legislative duty if they are not involved in these processes? The last process is the adoption of the proposed law or referendum, which happens even in Parliament. They must take a vote. Now let me pause and ask you a question, my ladies and my lords. Suppose a bill is brought to Parliament from God knows where, and it goes straight to the third reading, and members of Parliament are asked to vote for it. If they vote for that proposed law, will it become a proper law? Have they enacted that law? The answer is in the negative. That is what the appellants are telling you, that we should not worry about where that bill is coming from. We should not worry about the level of our participation. Ours is just to endorse. Then we will not have enacted that law. We will have endorsed but not enacted, contrary to Section 255, 256, and 257. I make this submission because looking at the nature of a popular initiative, once IBC is presented with 1 million signatures and a draft bill, there is no chance of in any way altering the contents of that bill. It proceeds to the county assemblies, National Assembly, Parliament, that is the Senate, to the President, and back to IBC, which presents the bill to a referendum. So then, if it doesn't matter what happened before, I challenge my learned friends to tell me at what point will Wanjiku really propose any amendment or deliberate over the content, and that voice matters. It doesn't. Three questions that the court must ask itself to understand whether this is a popular initiative or not, or whether the president can do that. Did the people participate in the formulation? Were there any awareness of the contents? Was there any content deliberation? If no, then the court must be very clear that this is not a popular initiative. It is something different. Secondly, the second reason why the president cannot be allowed to initiate a popular initiative is under the social contract theory. Now, under this theory, my ladies and my lords, we have two parties. On one end, we have the governors, that is the government, and the governed, that is the people. So when the people elect their governors, they remain at one end of that contract. The governors are on the other end. The president, in this context, is the governor, the government. The people remain as the governed. Now, in a social contract theory, it is the people who create the form of government and the framework of governance. It is not the other way around. Then after doing that, they donate the power to the governor to govern them in accordance with what they have already formulated. Therefore, the president cannot now shift goals from being a governor and now start formulating a form of governance and subject it to the governed. That would be in breach of the social contract theory. Now, just to emphasize on that point, the Constitution under Article 131(2) provides for exactly that. that a president will be given a constitution, he will be given an already created governance framework, and is required, number one, to respect, uphold, and safeguard that constitution. He is also supposed, under the same article, to safeguard the sovereignty of the republic. The republic is that he must recognize that these are the people who created this form of governance. These are the people who created this constitution. I have a duty to respect, to uphold, safeguard this constitution. So it is not for the president to create the constitution. It is not for the president to make the constitution or remake it. That is given to him once he enters into that social contract with the people. Now, purporting to remake a constitution will inevitably lead to him violating that duty under Article 131. Because under the social contract theory, the citizens are the right bearers and the governors are the duty bearers. So what the president has is a duty. What the people have is a right. His duty, as I've explained, is under Article 131 to safeguard that constitution. And just to ensure that the president understands this duty clearly, the third schedule of our constitution provides an oath of office, which states again as follows, that the president swears to obey, to preserve, protect, and defend the constitution. I'm only interested in one word, in those 5 words, to preserve. Ordinary English means to maintain in the original state. That is what he swears to do, to preserve the constitution. So upon the end of his term, and he has changed the constitution, will he have lived to his oath of office to preserve that constitution? It doesn't. He will have breached the constitution. Now, I find it a bit glaringly contradictory for the Attorney General to argue on one hand, and I think my learned friend Mr. Avi has touched on this, but I need to emphasize that indeed the president is an ordinary citizen for the purposes of enjoying rights under Article 19. Well, that is true, but then it is only true at the beginning when he is seeking to cross to the other floor, to become the governor, not the governed. So at that point, the president is at the same footing with every other citizen. But the moment he swears to defend the constitution, the moment he's given state authority, then he crosses over. And Article 24 now must come in to limit the exercise of his private rights. And the reason being, it is very difficult for you to distinguish between the president as a person and the president who occupies the office. Still, even if he says, I am a private citizen, state resources are still at his disposal. His political influence is still at his disposal for use. It is for that reason, and as a matter of necessity, that now Article 24 must come in and limit the exercise of his rights. And that is also confirmed by Article 143, because my learned friends cannot argue, on one hand, that indeed the president is an ordinary citizen, but still, under Article 143, he enjoys immunity. It is a contradiction. It must mean that Article 143 comes in because he's been elevated above the ordinary citizen. To answer a question that was posed by this bench as to whether the president initiated this initiative, I'll have 2 questions, my ladies and my lords. Number one is that this is an issue of fact, which was adequately canvassed at the High Court and the Court of Appeal. My understanding is that that is a settled issue that we cannot revisit at this stage. It is not in doubt because it is a factual issue. But if I was to answer that question, I would still go ahead and pause. Did we still witness the President's involvement even at the point of signature collection? And the answer is yes. So the President did not just stop at receiving the proposals. He went ahead and, number one, launched the signature collection at KICC. That is contained in our pleadings, and used state machinery to ensure that they collect their million signatures. On the question of public participation, I think there is no doubt, my ladies and my lords, that public participation has been entrenched in our Constitution and Article 10. The question is, what is the level and threshold of public participation in a process such as amending the Constitution? Now, to answer this question, we do not even need to go very far. I'll refer you, my ladies and my lords, at the preamble of our Constitution, which, with your permission, I'll read. And I'm looking at the last two bits of our preamble. In exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution, we adopt and enact and give this Constitution to ourselves and to our future generations. Now, I pick a few things from there. Number one is that the people are saying we have the sovereign power, the inalienable right to determine our form of governance. And for them to be able to exercise that, they are saying we are doing this after fully participating in the process of making this Constitution. That is the level of public participation. That is the threshold. Fully participated in enactment of the Constitution. Fully. And I started by explaining what enactment means. Formulation of the bill, creating awareness, content deliberation. That is what it means to fully participate. That is in the preamble of our Constitution. That is also captured under Article 1 of our Constitution. An argument has been advanced that then we are not making a constitution. We are merely amending a constitution. Therefore, we do not need to fully involve the people. But is that so? Are we really amending the Constitution? The impugned bill that is before you, my ladies and my lords, is it an amendment? Or is it a process of making a constitution? Now, I want you to pause there, my ladies and my lords, and ask yourselves, if today we were in a constitutional moment, and by that I mean the moment we were in pre-2010, would we rush to Article 255, 256, and 257? The answer would be no. If we want to make a new constitution, because I do not doubt that we have a right to replace this constitution, just like we did in 2010. But if that moment comes, is that procedure provided for under 255, 256, and 257? The answer is no. Does it mean we cannot amend that? We cannot replace this constitution? Again, the answer is no. It only means that we have to go beyond the provisions of Article 255 to find the procedure elsewhere, because this constitution does not provide for its death. It does not provide for its replacement. There isn't any constitution in the world that provides for its replacement. There is no procedure. So therefore, when there is desire to amend, or rather to replace the constitution, you cannot find that procedure under Article 255. I started by arguing that this was not an amendment. And I'll refer you to the Black's Law definition of an amendment. And my learned friend Harvey has mentioned a bit of it. I'm referring to the Black's Law Dictionary, the 9th edition, at page 94. An amendment is a right to correct or rectify. Now, the same Constitution has provided the meaning of repeal, which is what I'm talking about, replacement. And this is how it defines it. A repeal is done by specific declaration of a new statute or law. That is what we did in 2010. We declared a new statute, a new law, and did away with the one we had. That is called an express repeal. The same law dictionary now goes to the second definition of repeal, which is implied repeal, which has been defined to mean where the new law or the amended law brings about irreconcilable difference or conflicts between the old law and the new law, such that the new law cannot be mentioned to go hand in hand with the previous law. It is our submission that the bill before you was an implied repeal to our Constitution. Why am I saying so? This bill has some irreconcilable conflict with the form of governance that we have under the 2010 Constitution in terms of separation of power, in terms of the independence of the judiciary, in terms of the form of governance. So you cannot talk about this Constitution and still talk about interfering with separation of powers through an amendment. It is an implied repeal. It is for this reason that the High Court judges and the Court of Appeal judges identified that for you to alter this Constitution, for you to impliedly repeal this Constitution, you must go beyond 255. You must go outside what is provided for under this law. And that's why they came up with the 4 sequential stages. And that is based on our history. Civic education, public participation, which must entail collection of views, consultation through assembly debates, consultation and public discourse, and finally, a referendum. You have been told that this process begins at the point of signature collection. I beg to differ. There must be other processes that lead to the formulation of this bill. It is only through a 4 sequential process that we are able to achieve all the stages of enacting a law, because in this case, we are exercising legislative duty. On my last part, before I invite my learned friend to submit, because she's submitting on one issue, I'll pause and ask then, who has the duty? Who is the duty bearer to ensure there is public participation? Now, Article 88 of our Constitution provides for the responsibility of IBC, number 1, to conduct and supervise referenda and elections. So once IBC has been presented with their million signatures, and not just signatures, the law provides that those signatures must be in the company of a draft bill. It should ring in the mind of IBC that a process under Article 88 has begun. Their duty begins then. It does not come at the point of a referendum. You, my lords and my ladies, have argued before that election is a process. It's not an event. So once IBC is presented with that bill, and you will note that under Article 257, there is no time limit for IBC to satisfy itself, because there is a requirement that it should satisfy itself that the bill is in compliance with this article. There is no time limit. Then I submit, at that point, IEBC has a duty under Article 88 to ensure that before they formulate that policy, before they make that decision to forward the bill to county assemblies, that Article 10 has been complied with. They cannot run away from that responsibility. It is their duty. They must know at the end of the day, this is a bill capable of going to a referendum. So a process has begun. So then I submit that, just like in an election process, where IEBC is seized of the process right from nomination of candidates, it does not wait until 9th of August 2022 for it to say, now we are conducting an election. They begin their mandate as early as nomination of candidates. In the same way, once a bill is presented to them, it is upon them to ensure that there is adequate public participation. Because time only starts running once the bill is presented to the county assemblies with no option of any citizen's view being accommodated in the bill. I submit that that duty lies with IEBC to ensure that there is public participation once they receive that bill. In conclusion, therefore, I urge you, my lords and my ladies, just like the 5 justices of the High Court smelt a skunk, despite it being given a new name, just like the 7 justices of the Court of Appeal smelt it correctly and pronounced it to be a presidential initiative as opposed to a popular initiative, just like legal scholars have done, I urge you, with tremendous respect, my lords and my ladies, to declare this as the same. It is a presidential initiative which has no place under Article 255, 256, and 257. I beg to rest and thank you so much. I invite my learned friend to address you on the question of multiple referendum questions. Thank you.
Good afternoon. Alongside Mr. Mutuma, as he has introduced me, for the 7th, 8th, and